give a little brief introduction of why we're here and what we're trying to accomplish. The Foreign Intelligence Surveillance Act is a tool that's been around for a very long time for our intelligence community, the FBI, to make sure that when foreign agents, terrorists, or agents of a foreign government are in our country, they can be surveilled if they're doing things that are threatening to our national security. I think this legislation goes all the way back to the 70s, and it's been used a lot. It's been used in terrorist cases when we suspect someone of being a terrorist. Under the Foreign Intelligence Surveillance Act, we have the legal authority to surveil those people. And you can get a warrant under the Foreign Intelligence Surveillance Act to actually follow an individual around. And I would say, at least on our side, the FISA system is very much in jeopardy. The Carter Page warrant application is very unnerving. The Crossfire Hurricane, Crossfire Razor investigations, I think have really shaken confidence in the system. And my goal as chairman, and this will go into the next Congress no matter who's in charge, Senator Feinstein, is that FISA needs to be reauthorized, but right now, without substantial reform, I don't think we could get it reauthorized. And my goal is to understand how the system failed, how it got off the rails, and be able to assure the American people and ourselves that what happened here will not happen again. So the Horowitz report is sort of the basis of what I've been trying to do. Mr. Horowitz is the Inspector General at the Department of Justice, and he did a deep dive into the FISA warrant applications of Carter Page, and he found 17 significant errors in admissions, and the committee in its work has found some other things that were pretty disturbing. So we've tried to use the foundational document, the Horowitz report, and I want to thank Mr. Horowitz and his team for their thorough examination of the FISA Carter Page warrant application. They found evidence that the primary Russian subsource was a single individual. They found interviews in January and March of the subsource where he basically said the dossier, which was central to getting the warrant against Carter Page, was bar talk, hearsay, and quite frankly, much worse. We found that the primary subsource, a gentleman named Igor, was actually suspected by the FBI of being a Russian agent all the way back to 2009. And what happened here is, as a result of this information, the FISA court issued an order rebuking the FBI and Department of Justice conduct. And where's that final paragraph there? This is what the FISA court. The FBI's handling of the Carter Page applications as portrayed in the OIG report was antithetical to the heightened duty of candor described above. The FISC expects the government to provide complete and accurate information in every filing with the court. Without it, the FISC, the FISA court, cannot properly ensure that the government conducts electronic surveillance for foreign intelligence purposes only when there's a sufficient factual basis. So we're trying to find out, as the Committee of Oversight of the Department of Justice and the FBI, how this happened and to make sure it never happens again. So the basis of our inquiry started with the Horowitz report, an independent agency within the Department of Justice, and we're going to look at the FISA rebuke and see if we can find a way to convince the court in the future that this problem has been solved very quickly. Carter Page was on the Trump campaign team. He was one on the national security team, and here's what we learned. If you've had a photo with President Trump, you probably spent more time with President Trump than Carter Page. Carter Page is an interesting character, but the FBI sought a FISA warrant against Carter Page for suspected ties to Russian intelligence operatives. They were unable to get the warrant approved internally just based on contact with Russian operatives. Mr. Page denied knowing half the people, and there's yet to be any indication that he was lying. And the other group that he was associated with were foreign intelligence operatives of Russia, but he told the FBI early on, I was working with the CIA. That's why I knew these people. And the CIA confirmed to the FBI that was true, but later on, Mr. Kleinsmith doctored the information coming over from the CIA to say that Mr. Page was not working with the CIA. Why is that important? If the court had known that these contacts had a legitimate purpose, there would have been no basis for the warrant. How would you like in your case for the government to alter a document that was exculpatory to you? And that's what happened, and that's a criminal act that's going to continue to be prosecuted, I hope. But during the course between October and June of October of 2016 and June of 2017, the dossier that was central and essential to getting the warrant had so many holes shot through it that it became almost a joke. The point is, without the Russian Steele dossier, there would have been no warrant because they tried just based on Russian context. It wasn't until the dossier appears on the scene that they were able to go and get a warrant. The dossier was prepared by a man named Christopher Steele, who was hired by Fusion GPS, that was being paid by the Democratic Party and the Clinton campaign to do opposition research against candidate Trump. He had a subsource, we didn't know until now, it was a single individual that he hired named Igor, and we now know that Igor was suspected by the FBI back to 2009 as being a Russian agent / spy, a national security threat to the United States. That's the man that gave all the material to Mr. Steele. I will go in pretty deep detail about how the dossier over time not only became unreliable, it just lost all credibility, and the court was never told of the information that was obtained between October and June. The FBI ignored exculpatory evidence, altered documents from the CIA, had interviews where the subsource disavowed the accuracy of the document, and never submitted any of that information to the court. This, to me, is a stunning failure of the system to work. And I will end with this. Warrant applications are non-adversarial. If they're trying to get a warrant against you or your family, there is no lawyer there to protect you. The court has to rely on the agents, the department, to be honest and forthright when it comes to obtaining a warrant against an American citizen, criminally, or even in the FISA arena. So here's the question. What do we do when we find that the warrant application relied upon a document that was fundamentally unsound, that the FBI ignored all the warning signs about this document, misled the court about the author and the reliability of the document, and over and over and over again it was used to keep an investigation of an American citizen alive that we now know had 17 irregularities? What do? We just say, well, that was bad, that's the way it goes. Does anybody get fired? Does anybody go to jail? And I'm saying this to my Democratic friends, if it happened to us, it could happen to you. Every American should be worried about this. This is not just an abuse of power against Mr. Page and the Trump campaign. This is a system failure. And you could be next. So the joint effort of this committee, in my view, should be to make sure this never happens again, starting with finding out who did it, who's responsible. Apparently everybody's responsible, but nobody's to blame is not the right answer. So my goal is that we can have a deep dive and understand how this happened and working together to assure the American people it never happens again to any political campaign of any party, and that the FISA system can survive this very sad chapter. We're turning the page on a very dangerous chapter in the history of the FISA program. We're trying to start anew, and the only way we can start anew is to find out what happened and hold people accountable. We're not prosecutors here. There are people out there who do have prosecutorial authority. We'll let them decide what to do, independent of us. But it is a responsibility of this committee to try to restore trust in a program that we all need. And we will start that endeavor seriously today and continue until we get to the bottom of it. I have two documents I'd like to introduce for the record. I have an Office of Intelligence Attorney statement. This is the DOJ lawyer that signed off on the FISA application, and the letter says, the attorney advises that had he/she been aware of the significant errors and omissions identified by the OIG Inspector General and the errors in the Woods process, he/she would not have signed the Carter-Page FISA applications. The OI attorney further advises that he/she is not aware of any additional errors or omissions in the Page FISA applications or in the Crossfire Hurricane investigation more generally that were not identified in the OIG report. This is yet another person saying, if I know then what I know now, I wouldn't have signed this report. Horowitz did a really good job. Rosenstein and Sally Yates said to this committee, who signed the warrant application, if I knew then what I know now, I would not have signed this application. This is the lawyer that prepared it saying the same thing. Thank you, Senator Feinstein.
Mr. Chairman?
Yes, sir.
May we have copies of that document, please?
Yes, we'll submit it to everybody.
Thank you.
Thank you very much.
Thank you very much, Mr. Chairman. We are here again today as part of the Chairman's examination of Crossfire Hurricane, the FBI's Russia investigation. The President has long claimed that the investigation of his campaign was a witch hunt and a hoax. Contrary to the President's claim of a witch hunt, the Department of Justice Inspector General Michael Horowitz confirmed in a detailed report that the FBI was justified when it opened the investigation into ties between the Trump campaign and Russia. The FBI learned in July of 2016 that the Trump campaign appeared to have advanced knowledge of Russia's plans to release, quote, thousands of emails, end quote, to harm Hillary Clinton and help Trump. The FBI learned this 1 week after WikiLeaks published 20,000 emails that Russia had stolen from the Democratic National Committee's hacked computers. The DNC hack and the possibility that the Trump campaign knew of Russia's plans to interfere in the 2016 election by releasing stolen emails created a significant counterintelligence concern. Mr. Comey has said that the FBI, quote, would have been derelict not to investigate, end quote, and I agree. Special Counsel Robert Mueller assumed control of Crossfire Hurricane after Mr. Comey was fired by President Trump. Mueller's findings confirm that the FBI was correct to investigate. Mueller found that the Russian government, quote, perceived it would benefit from a Trump presidency and worked to secure that outcome, end quote, and that the Trump campaign knew about, welcomed, and, quote, expected it would benefit electorally from Russia's interference. Mueller also uncovered numerous contacts between the Trump campaign and individuals linked to Russia. For example, Mueller found that Trump campaign manager Paul Manafort gave internal polling data and campaign strategy to Konstantin Kilimnik, a Russian intelligence officer. The Senate Intelligence Committee, of which I'm a member, recently issued the bipartisan finding that Manafort was, quote, a grave counterintelligence threat, end quote, because of his ties to Russian intelligence. So think about that for a moment. the president's campaign manager had ties to Russian intelligence and could have used them to share confidential campaign information. Mr. Chairman, of course, the FBI should have investigated. Unfortunately, the president and his allies have been trying to rewrite the Russia investigation since the day it concluded. They have seized on errors in the FBI's applications for FISA surveillance on Carter Page to assert that the entire Russian investigation was corrupt. Those errors were serious, but the errors and the so-called Steele dossier, and this is important, played no part in the broader Russia investigation. This was confirmed by Inspector General Horowitz and former Deputy Attorney General Rod Rosenstein, who told the committee that none of the Mueller report's findings of criminal charges rely on the Steele dossier, none of them. President Trump and his allies also claim that the Russia investigation was a political witch hunt overseen by investigators who hated the president. But Inspector General Horowitz found no evidence that political bias impacted the Crossfire hurricane, and none of the 10 witnesses the committee has interviewed during the chairman's investigation provided such evidence either. We should not ignore or excuse what happened in 2016. FBI Director Wray and the intelligence community have warned that Russia is interfering in the 2020 election with the aim of denigrating Vice President Biden. We should condemn Russia's current and past interference, not downplay it. And we should insist that the president reject Russia's interference as well. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. Is Mr. Comey, our technology, working today? Mr. Comey, can you put him up on the screen? Mr. Comey, could you speak, please? That would actually.
Yes, I can hear you.
Okay, great. Thank you. Will he be on the screen? Okay, can you count to 10 for us, please?
Sure. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Well, you did your part. There we go. 11 must have been the magic number. Thank you very much for being with us. Could you raise your right hand, please? Do you solemnly swear that testimony you're about to give this committee is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You'd like to make an opening statement? You may, if you'd like.
I have no opening statement. I'm ready for your questions.
Well, one, thank you very much, and I'll take a little more than 5 minutes here, but we'll try to plow through it. Mr. Comey, on a scale of 1 to 10, with 10 being the top of the line, great, how would you rate the Crossfire hurricane investigation in terms of being done thoroughly, by the book, an investigation the FBI should be proud of?
I'm not sure I can apply a number scale, but I would say in the main, it was done by the book, it was appropriate, and it was essential that it be done.
Okay. So you're proud of it?
Overall, I'm proud of the work. There are parts of it that are concerning, which I'm sure we'll talk about, but overall, I'm proud of the work.
Okay, sounds good. Okay, when did you first learn of the existence of the Steele dossier?
Sometime towards the end of September of 2016.
Okay. Do you agree with Mr. Horowitz that the dossier was central and essential to the Carter Page FISA warrant application being approved?
I agree that it was important. I can't tell you whether it was essential, and by that I mean that it wouldn't have been granted without the Steele information.
Let's go through the application. There are two parts to the application. Was there an effort to get a warrant approved without using the dossier?
Yes, my understanding is in the summer, they asked DOJ whether they would support moving forward on a warrant application.
And they said no, right?
Correct. That's my understanding from the Horowitz report.
Then you add the dossier, all of a sudden they say yes to the warrant application. Is that a fair statement?
I think it's fair to say that DOJ decided to move forward after the Steele information was part of it.
Yes, so I would say that it was central, essential based on that. Now, here's what I'd like to ask. The contacts between Mr. Page and alleged Russian operatives are one part of the application, is that correct?
That's my recollection.
Okay. Did Mr. Page deny knowing people that you accused him of having contact with?
I don't remember. I think the Horowitz report says that in the fall of 2016, speaking to an FBI source, he denied knowing certain people, but that's about all I recall.
Well, here's the facts. He denied knowing these people, and the FBI is yet to find any evidence that he was lying. The people that he did have contact with, did he tell the FBI that he was working for the CIA and that's why he had contacts with these people?
I don't remember that.
Do you now agree that the CIA confirmed that Mr. Page was in fact helping them?
I know from the Horowitz report that the CIA confirmed he was what they call a contact.
So the FBI in August of 2016 had information from the CIA informing the FBI that in fact Mr. Page was a resource. Did you not know that?
I did not know of the nature of his relationship with the CIA. I know what I'm telling you is what I read in the Horowitz report.
Do you think it would have been fair for the FBI to tell the court that Mr. Page had a reason to be talking to these people because he was working with the CIA? Would that have been a fair thing to tell the court?
I don't agree with your characterization of what Mr. Horowitz found. So
No, I'm talking about you as a director. The FBI has in its possession in August 2016 information from the CIA confirming what Mr. Page said, that he in fact was assisting the CIA, which explained the contacts. That was never given to the court. Should they have been informed of that? Because that's exculpatory to Mr. Page.
I believe Mr. Horowitz found that they should have at least considered informing the court.
You're the director of the FBI, would you wish that had been done if you had known about it?
I'm sorry, Senator, that what had been done?
That you had informed the court that Mr. Page was in fact working with the CIA, and that explains these contacts. Do you think out of a sense of fairness, the court should have been informed of that fact?
Again, I don't agree with your preamble. I don't think the record established that he was working with the CIA. I think Horowitz found he was a contact, which means
we got the email from the CIA confirming that he was a source for the CIA. Are you aware of the fact that that email later on was doctored?
Again, I don't accept what you said. I don't think the record establishes he was a source for the CIA. I am aware from the Horowitz
Why is
report.
Mr. Kleinsmith facing criminal indictment?
I only know what I've read in the public record, that he was accused of changing.
You're the director of the FBI. You didn't know that your own agency had information from the CIA verifying what Mr. Page told you, that these contacts had a basis, in fact, because he was working with the CIA. Did you know that Mr. Kleinsmith doctored the email for it to read that there was no association between Page and the CIA, that he changed there was to there was not? How do you feel about that?
I know nothing about Mr. Kleinsmith other than what I've read in the public
Well, how do you
record.
feel in general about an FBI lawyer doctoring information exculpatory to somebody being surveilled?
Any false statement in the course of an investigation is deeply
But you didn't know anything about that, okay? In October, when the warrant was submitted, the application was submitted, what effort had been made to verify the dossier in October?
I don't know specifically. I know the Counterintelligence Division was working to see how much of it they could rule in and rule out.
How much time did they spend ruling in and ruling out regarding the dossier? In
I do
October?
not.
You don't know?
I don't.
You signed the application. Whose job is it to make sure the facts are right when you present them to the FISA court?
Well, the most basic level, the affiant, whoever is signing the affidavit.
Did you
And then-
sign the affidavit?
No, I signed a certification, which is required of the FBI director.
Okay, does the FBI director have any responsibility to make sure the facts are right when they're given to the court?
Not in connection with the certification, but in general, the FBI director is responsible for everything that's being done underneath the FBI director.
What we're trying to find is who provided the application to the FISA court and why was it so flawed? Can you give me a group of people we can look at to hold accountable for misleading the court? Who should we be looking at?
To understand the process in general, and in this case, you would start with the Horowitz report, where he recounts all the many people involved in the review, production, and delivery to the court of this application.
But you don't know, as the director of the FBI, who actually prepared the application. Is that correct?
I do not.
Okay. All right. So in October, it's clear, Mr. Comey, there was no effort to verify the dossier before it was given to the court. Do you agree with that?
I don't know the answer to that.
Well, that's the answer. In January of 12th, 2017, the warrant application was renewed. Did you sign that?
I signed a certification in connection with, I think,
Okay.
2 renewals, one in January and one 3 months later.
Are you aware of the fact between October and January, the FBI had found that the Russian subsource was on the payroll of Mr. Steele, was suspected of being a Russian spy by the FBI all the way back to 2009?
I don't remember learning anything additional about Steele's sources between
How can it be, Mr. Director, that the FBI finds in its file that the man that prepared the dossier for Steele was suspected of being a threat to national security, and it doesn't make it up to you?
I don't know. I could speculate, but I don't know. I haven't
Well,
spoken to the
I don't want you to speculate. We'll try to figure this all out ourselves. Do you know who Christopher Steele was? When did you find out who he was?
When the Steele dossier was briefed to me sometime, like I said, I think late September.
Were you ever told that he hated Trump and he wanted him to lose, and he very much down on Donald Trump as a person?
Not that I recall, no.
You don't remember Bruce Orr briefing the team about Steele's biases, that you have to really watch this guy?
I don't remember Bruce Orr ever briefing me.
Do you remember friendly foreign governments putting us on notice that he tends to exaggerate? He goes off on crusades. Did that make it to you?
I don't recall that.
Okay, thank you. All right, so should the court have been informed in a perfect world that the primary subsource was a suspected Russian spy?
At a minimum, the team of the FBI and Justice should have discussed whether to inform the court about that.
Were you aware that in December 2016, the CIA tells the FBI they characterized the dossier as internet rumor?
I don't recall being informed of that.
Were you ever told by the CIA to be careful with the dossier and Steele, that that this is not good craft here?
I don't remember ever being told anything like that.
Okay. All right, so let's fast forward now. The warrant application is renewed in April 2017. You signed it in January the 12th. You didn't know that the primary subsource was suspected by the FBI of being a Russian spy all the way back to 2009. You didn't know that the CIA had told the FBI the document's internet rumor. Are you aware of the fact that the subsource was actually interviewed by the FBI in January 2017?
I don't remember anything about interviews of the subsource.
So as the director, was this an important case for the FBI, or is this kind of a run-of-the-mill thing?
The overarching investigation was very important. The Page slice of it, far less given
Well,
the
I mean, you
scope.
have a sitting president of the United States by January 2017. You have a dossier that's salacious as hell that accuses the president of being involved in all kind of sex escapades in Russia and a bunch of other stuff. And you keep using that document over and over again to get a warrant. And here's my question. Every time you found information to put the reliability of the dossier in question, everybody seemed to ignore it, just plowed forward. So I want to know, in January, you're not aware of the fact that the FBI interviewed the primary subsource. Is that your testimony?
I do not remember being told about any interview of.
Should you have been told about it?
I can't answer that because I wasn't, and so I don't know what the considerations were that
Well,
the team.
here's what happened. The primary subsource told the FBI in January 2017, after the dossier had been used twice to get a warrant, that the subsource has no idea where some of the language attributed to him came from, that the contacts never mentioned some of the information attributed to them, and that he did not know the origins of other information that was supposedly from his contacts. He said the statements were word of mouth and hearsay, conversations had with friends over beers, and were statements made in jest that should be taken with a grain of salt. Did any of that ever get to you?
Not that I recall, no.
Do you agree that's pretty important information concerning the reliability of the dossier?
It's information that should be weighed in light of a variety of circumstances.
It's inherently exculpatory. The person who put the document together is telling the FBI, it's bar talk, it's grain of salt. They tell the FBI, and they keep using the same document. You know how they describe to the court the subsource? You know what they told the subsource in the application, the court about the subsource? That he was truthful and cooperative. Do you think those terms to the court, truthful and cooperative, fairly reflect the interview the FBI conducted in January and March?
I know the Inspector General found the disclosure was inadequate in that regard.
Not only, Mr. Comey, is it inadequate, it is criminally inadequate. You have a document central to getting a warrant against an American citizen. It is falling apart. The CIA says it's internet rumor. The person who prepared it was on a jihad against Trump on the payroll of the Democratic Party. The primary subsource was a Russian agent. When that person was interviewed by the FBI, he disavowed the reliability of the document to the point that it should never have been used again. And my question is, how could the system ignore all that? And how could it be used again in April and again in June? Do you know how that's possible?
Again, I'm not going to respond to your preamble. I think Mr. Horowitz found that it was not disclosed, and a variety of facts were not disclosed. He didn't find intentional misconduct, but he found concerning failures to disclose.
All I can say is there a duty by the FBI to inform the court of exculpatory information?
There is a heightened duty of candor, which includes exculpatory information and anything that might be relevant to the court's
Do you
consideration.
think it's exculpatory for Mr. Page, for the court to know that when he said the people he met with was a result of him being associated, working with the CIA, do you think that would have been beneficial to Mr. Page?
Again, because I don't agree with your predicate to the question, I can't answer that.
Well, we got emails, and I'd be glad to show them to you about the association between the CIA and Mr. Page. Do you think it would be only fair for the court to be told that the primary subsource disavowed the document as being rumor, bar talk? You take half of it with a grain of salt. Do you think the FBI owed it to the court and Mr. Page to tell the court about these stunning revelations?
I think Mr. Horowitz found, and it seems a reasonable conclusion, that they should have informed.
How could the director of the FBI not know all of this? How is it possible that the system gathers so much exculpatory information? It's internet rumor according to the CIA, that the actual interview of the subsource disavows the reliability of the document, that the actual subsource was a suspected Russian spy. How could all that happen and not get up to you, the director of the FBI, of one of the most important investigations in the history of the FBI. How is that possible?
I can only speculate because it didn't. And as I said, the investigation overall was incredibly important. The piece you're focused on is obviously important, but a much smaller slice
Well,
of
it's
the whole.
very important to Mr. Page. It should be important to every American. Is there anybody there advocating for Mr. Page during the warrant process?
No, it's an ex parte application, meaning there's only one side represented.
And I just want to understand this. It's an ex parte event. It means that the cops have a duty to tell the court when they find things beneficial to the person under investigation. And over again between October and June, all the information found about the dossier made it less reliable, not more reliable, and you kept using again and again and again. And the question was their bias. At what point in time do you put two and two together? That the people behind this hated Trump, and the reason they ran all these stop signs, they didn't want to take no for an answer. So do you recall getting an inquiry from the the intelligence community in September 2016 about a concern that the Clinton campaign was going to create a scandal regarding Trump and Russia?
I do not.
You don't remember getting a investigatory lead from the intelligence community? Hang on a second. Let me find my document here. September the 7th, 2016, the U.S. intelligence officials forwarded an investigative referral of to FBI Director James Comey and Assistant Director of Counterintelligence Peter Strzok regarding U.S. presidential candidate Hillary Clinton's approval of a plan concerning U.S. presidential candidate Donald Trump and Russian hackers hampering U.S. elections as a means of distracting the public from her use of a private email server. You don't remember getting that or being taught? That
doesn't ring any bells with me.
Okay. Well, that's a pretty stunning thing. It didn't ring a bell, but it did come to you. Let's just end with this. You get this inquiry from the Intelligence Committee to look at the Clinton campaign, basically trying to create a distraction, accusing Trump of being a Russian agent or a Russian stooge or whatever to distract from her email server problems. And how far-fetched is that, Mr. Comey, when we now know that the Democratic Party, through Fusion GPS, hired Christopher Steele, a foreign agent who had a very strong bias against Trump, who hired a Russian subsource who the FBI believed to be a Russian spy to compile a dossier that was a bunch of crap to be used against an American citizen working for the Trump campaign. You already knew that. Seems to me you'd want to investigate other allegations, but you're telling me that you don't recall this.
I'm sorry, Senator, is your question?
Yes, you don't recall this inquiry I just read about September the 2016.
No, as I said, it doesn't, again, I
Do you
haven't read
remember
it.
being told?
But it doesn't sound familiar.
Do you remember being told by the the intelligence community? Remember the episode with Trump in the hotel with the hookers in the dossier?
Yes, I remember that portion.
Okay,
of
that's pretty hard to ignore. Do you remember in December, the Intelligence Committee basically said a U.S. intelligence community report contained information about the falsity of the details of Trump's sexual activity in Moscow and assessed that they were the product of Russian intelligence services infiltrating a source into Steele's network. So this is from the Horowitz report. In other words, the intelligence community had assessed that the dossier's description of a sexual escapade was actually a Russian disinformation campaign. Did you know that when it came out?
I'm not familiar with what you're reading from. I don't know whether the
It's in
incident.
the Horowitz report. I guess what I'm saying is that the Horowitz report has information they had in the file that the whole scenario with Trump and the sexual escapade was Russian disinformation. And you knew that, and you never told the court. To me, that is something that the court should know. If, in fact, the Russians had infiltrated Steele's sources to create this myth about sexual misconduct of the president, that to me seems to cry out for slowing down and stopping, not keep using the document. All I can say is that you've believed it would be a dereliction of duty not to look at Trump-Russia. I'm not here to argue that nobody should look. I'm not here to argue that it was somebody other than the Russians who hacked into the DNC. It was the Russians. What I'm here to say is there were ample evidence of the other side being involved with Russia to create a scandal around Trump. They hired a foreign agent on the payroll of the Democratic Party who hired a Russian spy to create a document that was absolutely full of misinformation and complete lies. Did you know there is no Russian consulate in Miami? And the dossier mentions that there was one. Shouldn't the court have been told that part of the dossier is not reliable? Do you also know that Michael Cohen's adventures in Prague never happened? The dossier asserts that Michael Cohen went to Prague on some venture for Trump in Russia, and it never happened. And they know it never happened. They had information from a foreign government saying it's not true, and they never told the court. They never corrected all the misinformation in the dossier. It was used over and over again, and they never told the court about how unreliable it was. Is that a small thing or a big thing?
Anytime there are material omissions in an application to a judge of any kind, but especially in an ex parte proceeding, it's a very important issue.
Did you have a duty to look at any allegations regarding Clinton and Russia?
I don't know what you mean.
Well, you say you had a duty to look at allegations about the Trump campaign being involved with the Russians. You've got a letter now from Radcliffe saying that they intercepted information about an effort in July where Hillary Clinton approved an effort to link Trump to Russia, the mob. Did you have an investigation to look and see whether that was true?
I can't answer that. I've read Mr. Radcliffe's letter, which frankly I have trouble understanding.
Okay. Thank you very much.
Thank you, Mr. Chairman. The president and his allies argue that the FBI should never have investigated the Trump campaign's ties to Russia. However, Special Counsel Mueller and the Senate Intelligence Committee found that the Trump campaign manager, Paul Manafort, gave internal polling data and campaign strategy to a Russian intelligence officer. The Senate Intelligence Committee issued the bipartisan finding that Manafort was a grave counterintelligence threat. I'd like to put in the record this report of the Senate Select Committee on Intelligence, Mr. Chairman. Thank you very much. Would you agree that a direct tie between a presidential campaign manager and a Russian intelligence officer is a grave counterintelligence threat?
Yes.
Could you tell us why, please?
Because someone who's occupying a role in the heart of American democracy, running a campaign, is in a position to supply information about that campaign and the workings of our democracy to a foreign adversary. That's the definition of a counterintelligence threat.
So you would agree that this type of counterintelligence threat does warrant investigation?
Yes, of course.
The Senate Intelligence Committee determined that Manafort's presence on the campaign and proximity to Trump created opportunities for Russian intelligence services to exert influence over and acquire confidential information on the Trump campaign. Does the possibility that Russian intelligence services are exerting influence over a presidential campaign create a counterintelligence risk that warrants investigation?
Yes, as the Senate Select Committee on Intelligence found last month.
Correct. Thank you. Special Counsel Mueller found that Michael Cohen, Trump's personal attorney, pursued the Trump Tower Moscow project on Trump's behalf during the campaign. Is there a counterintelligence concern when a candidate for political office pursues a lucrative business deal in Russia at the same time he publicly claims to have zero interests in Russia?
Yes, because of the ability that offers the foreign adversary to have leverage over that individual.
Correct. And does this type of counterintelligence concern warrant investigation?
It may, depending on what facts you have to predicate the investigation.
Thank you. You told the Inspector General that you received no requests from the Obama-Biden White House to investigate members of the Trump campaign. You've also said that if President Obama or a member of his administration asked the FBI to investigate the Trump campaign, your answer would be not only no, but hell no. Did President Obama or Vice President Biden ever ask you to investigate a political rival or to go easy on a political rival?
Never.
Why would that have been problematic?
Because it would compromise the independence of the Justice Department and the FBI's work. If it's a criminal case or a counterintelligence case, it would introduce politics into what should be a fact-driven process.
Thank you. U.S. intelligence has assessed that Russia is using a range of measures to primarily denigrate former Vice President Biden, end quote, and, quote, boost President Trump's candidacy, end quote. FBI Director Wray has said that Russia's anti-Biden efforts have been very active. President Trump has said that he would take damaging information on a political opponent from a foreign adversary, and that he would not commit to informing the FBI. He publicly asked China to investigate Joe Biden and was impeached for pressuring Ukraine to investigate Biden as well. Are you concerned that Trump will embrace and use Russian interference efforts to his advantage, excuse me, as he did in 2016?
Well, I'm a private citizen now, so as a private citizen, yes, and he said that he would.
Thank you. Thank you, Mr. Chairman.
Thank you, Senator Grassley.
Yeah. Thank you for your appearance here. On January the 6th, 2017, the Obama administration issued its intelligence community assessment on Russian interference in recent elections. That assessment included Annex A, which said that the FBI had identified and unidentified sources relating to the Steele reporting and Russian investigation. Prior to that, in December 2016, the FBI had identified Steele's primary subsource and knew that he was a subject of counterintelligence investigation. You either knew or should have known that the primary subsource was subject to counterintelligence investigation when you made efforts to include the Steele dossier in the assessment. Did you make any effort to ensure that Annex A identified that some sourcing may have been from a suspected Russian spy or otherwise unsubstantiated? If not, why not?
I don't remember any information reaching me about any investigation of a source of Steele's. And I know now from the public record there was some investigation back in 2009 that can cut both ways. So I don't know how the people working on the investigation thought about it.
Okay. The primary subsource was a suspected Russian spy. The subsource disavowed elements relating to the dossier. He was subject to a counterintelligence investigation and offered people money for classified information. Shouldn't you have investigated the primary subsource instead of Trump, Page, Flynn, Papadopoulos, and whatever else?
I'm not able to answer that question because I don't know the details of the investigation back in 2009.
Okay. Thanks to declassified footnotes from the Inspector General, we know the following. 1, the FBI knew the Russians had the intent to target Steele. 2, we see that they had the opportunity to do so by various contacts Steele had with Russian intelligence assets. 3, we see the success of those efforts because some Russian disinformation made its way into the Steele dossier. It looks like both the Democratic National Committee and Russian intelligence services manipulated the FBI under your watch. How could the world's premier law enforcement agency miss all of these signs?
I'm sorry, Senator, I disagree with a lot of aspects of your preamble, so I can't answer that one.
Well, it sounds to me like you should have known, and it pretty much speaks for itself that maybe you aren't on top of things the way you should have been. Question number 4. On February 14th, 2017, you met with the president, and he allegedly asked you to let Flynn's case go. In any of your meetings with President Trump, did you inform him that the Flynn case was supposed to be closed on January the 4th, 2017? And if not, why not?
I don't think I had any conversation with President Trump about Flynn's case except for that February 14th let it go conversation.
Well, if you had that conversation, then couldn't you have informed him that the Flynn case was supposed to be closed on January 4th, 2017?
I don't know why that would be a relevant fact for any conversation about Flynn lying to the FBI.
On January 12th, 2017, email to James Clapper, you stated that, quote, "We have concluded that the source, Crown, is reliable." On January the 12th, 2017, the FBI received a report outlining inaccuracies related to Steele's reporting about Michael Cohen. The report also assessed that the information was part of a Russian disinformation campaign. That same day, you signed a FISA renewal. The FBI received another report on February 27th, 2017, that also stated parts of the dossier were false and subject to Russian disinformation. You signed another FISA renewal on April 5th, 2017. Steele is clearly not a reliable source. Why did you say otherwise, and why did you approve the FISA application in light of the evidence?
What I said about Mr. Steele that you read at the beginning of your preamble was what I believed based on what I had been told. And the rest of the reports you've listed, I don't remember learning about them or being told about them. So I can't comment on whether they're accurate or not.
Did you ever speak with President Obama or Vice President Biden about any aspect of Crossfire Hurricane? If so, what did you discuss?
I don't remember any discussion. I remember sometime in the summer of 2016, I think August, during a meeting in the Situation Room, I told the president that the FBI was endeavoring to understand whether any Americans were working or associated with the Russian effort to attack the election. I didn't talk about any names, but I believe I alerted him to the general nature of the work.
Did you ever speak with President Obama or Vice President Biden about any aspect of the Flynn case? If so, what did you discuss?
I remember the Flynn investigation coming up once. I think it was January the 5th, when President Obama held me back to urge me to do the case in the normal way and to let him know if there was any reason that he should not be sharing sensitive information about Russia with the Trump transition. I assured him that I would keep him informed and I would conduct the investigation in that way.
During the January 5th, 2017 meeting between you, President Obama, Vice President Biden, Sally Yates, and Susan Rice, did you mention that Flynn's calls with the Russian ambassador appear, quote unquote, appear legit?
I don't remember using that word. If I used it, I would have meant authentic and not fabricated. I wouldn't have meant appropriate. But I don't remember using that word.
Okay, my time's up.
Senator Leahy, by remote.
Mr. Chairman, are we coming through there at the hearing?
You're good.
Okay. Well, Mr. Chairman, I'm afraid listening to this from the beginning that it seems more like a political errand for President Trump's reelection effort, and perhaps for some others on the committee. I think it's offensive to all Americans who pay taxes. I realize the president does not. But the Senate apparently has no time to address the deadly COVID pandemic that's surging again. It's taken more than 200,000 American lives. Instead, it seems, Mr. Chairman, your party, Republicans, are obsessed with two priorities. First, a mad rush to confirm a Supreme Court nominee on the eve of a presidential election, just a few days before the Supreme Court will consider the Republican lawsuit to strip millions of Americans of their health care. And then, of course, to once again investigate the investigators who are charged with responding to Russia's brazen attack on our 2016 elections, and then candidate Trump's really brazen embrace of that attack. I've always thought of this as the Senate Judiciary Committee, and I've appreciated my 40 years on it, but I have never thought of it as either the Trump reelection committee or any other reelection committee. And we shouldn't be debasing ourselves this way. Now, Director Comey, you and I have known each other for a long time. You served our country through both Republican and Democratic administrations. I expressed to you some of my strong disagreements with decisions you made as FBI director, but I also recognize you were placed in truly unprecedented situations. I've never questioned your integrity or your loyalty to the law and to the country. Now, whether Vladimir Putin is interfering in our elections or paying bounties to kill our troops or brazenly poisoning dissidents, it seems President Trump is incapable of publicly criticizing him. The Mueller investigation ultimately decided not to look into any financial relationships between the president and Russia, despite some on the team who believed that it'd be relevant to their central investigation. We now know that President Trump owes more than $400 million in debt to largely unknown sources. In 2014, the president's son said the Trump organization did not rely on American banks for financing. Instead, they received all the funding we need out of Russia. Now, that was a Trump statement, and not anybody else's. Now, you stated that you think it's possible the Russians have something over the president. Why do you believe that this is a possibility? Have you ever felt this way about an American president?
I've never felt that way about an American president. And I don't know whether the Russians have something over President Trump, but it's difficult to explain his conduct, his statements in any other way, especially his refusal to criticize Vladimir Putin, even in public. And so it raises a significant question, and obviously the question is only deepened by disclosure, if it's true, of significant indebtedness.
Enough to raise suspicions in your mind, based on your experience. Thank you. Now, yesterday, reportedly over the objections of career officials, the Director of National Intelligence, John Ratcliffe, declassified and released unverified Russian intelligence, likely disinformation about former Secretary Clinton. The information was rejected by the Republican-led Senate Intelligence Committee. But Mr. Radcliffe has refused to testify in public about our own intelligence agency's assessment. of global threats to the United States, including from Russia. Are you concerned, Mr. Comey, that intelligence leaders handpicked for their partisan loyalties are weaponizing intelligence by selectively releasing foreign disinformation and withholding credible U.S. intelligence assessments?
I don't understand Mr. Ratcliffe's letter well enough to comment. It's confusing. It contains within it a statement, I think, that it's unverified information. So I really don't know what he's doing.
I see so many of my colleagues on the other side trying to delegitimize the investigation into Russia's documented interference in our 2016 election. We know from our own reporting that Russia is again trying to interfere in our 2020 election. Just this month, FBI Director Wray testified that Russia is very active in its efforts to influence and undermine the 2020 elections. If you had to convey one message to the American people about the persistent threat of Russian interference in our democracy or any foreign interference, what would it be?
Know that a nation that does not have America's best interests at heart wants to reelect Donald Trump. Let that sink in. Let it guide how you think about the way we ought to conduct ourselves going forward.
Thank you. I have a similar feeling. And you, yesterday, the former National Security Advisor, Michael Flynn's lawyer, was pressed by a judge about her communications with the Justice Department and the White House. After initially trying and failing to claim executive privilege, and after making the argument for months that Flynn was not receiving special treatment, she revealed that she has directly talked to President Trump about the case, has asked him not to pardon Flynn. Astonishingly, she also revealed that she talked to a Trump campaign lawyer about the issue as well, as in part of the Trump re-election effort. Now, you once supervised this investigation. What does the disclosure mean for how the Trump administration politicizes its official law enforcement responsibilities?
Well, again, I've watched this as a private citizen, read the pleadings in the court case involving former National Security Advisor Flynn, and I think the department's conduct in handling it is deeply concerning, best summarized by the retired federal judge who briefed the issue for Judge Sullivan in the District of Columbia District Court. It's deeply concerning because this guy is getting treated in a way that nobody's ever been treated before.
Thank you very much. And Mr. Chairman, I may have, after hearing the other questions during this hearing, I may have some questions for the record.
Absolutely, Senator Lee. Senator Cornyn.
Director Comey, is it appropriate for the Federal Bureau of Investigation to influence a presidential election?
The FBI should do everything it can to avoid having any impact on an election of any kind, including a presidential election.
Are you aware of the allegation against you that your handling of the Hillary Clinton email investigation, your press conference on July the 5th, your subsequent announcement that based on Anthony Weiner's laptop information that you were reopening that investigation in the day in the run-up to the election? Are you aware of the allegation that you were responsible for Hillary Clinton's defeat?
Yes, I'm aware of that allegation.
Does that concern you?
It concerns me whenever anyone has questions about whether the FBI is conducting itself in a competent, honest, independent way.
Did you call the Steele dossier salacious and unverified?
I called a portion of it that related to alleged sexual activity. I think that's the term I used to describe that.
You did not refer to it as unverified?
I think the term salacious and unverified, again, it's not all that important, but I think I reserved that for the sex part of it. The entire dossier was something we were trying to see if we could rule in, rule out. So the entire thing as to the FBI was unreviewed when it came in the door, and there was an effort to see what was true and wasn't true.
Short of Inspector Horowitz's report, are you aware of any verification of the Steele dossier by the FBI?
Sorry, Senator, I'm not tracking the question. I apologize.
We got a comprehensive report from Inspector General Horowitz on the Steele dossier. But before the Inspector General's report on the dossier, which tells us a lot about what we know now that we didn't know then, did you know that the information that was reported by Inspector Horowitz that should have raised questions about the reliability of the Steele dossier?
Oh, I see. I'm sorry. I learned a lot about the Steele material and the subsource interviews from the Horowitz report that I didn't know before then.
Can you rule out the possibility that the Crossfire Hurricane investigation was predicated in part on Russian disinformation?
I think so. I think both your colleagues on the Senate Intelligence Committee and the Mueller report and the Inspector General found that it was predicated based on credible information from a friendly foreign nation's ambassador.
So you're saying even though we know now that the subsource for the Steele investigation, or for the Steele dossier, was a Russian agent, that doesn't, in your view, taint any of the basis for that investigation?
First, I don't agree with your predication with respect to the FBI's investigation of the subsource, but the investigation wasn't open based on anything from Steele. It was open based on information from an allied ambassador about something a Trump foreign policy advisor said in London about the Russian offer to the campaign of dirt on Hillary Clinton. It wasn't until 2 months later that the Steele material came to the team.
The Steele dossier was used to secure a FISA warrant, correct?
Correct.
Back in January, after the election, the intelligence community submitted a report, intelligence community assessment. Do you recall that?
I do. The LCA from January 6th, I think, or 5th of.
I think that's right. Do you recall a discussion between you and the CIA about whether the Steele dossier should be included as part of the intelligence community assessment?
I remember some interaction with my fellow leaders of the intelligence community agencies that were part of that assessment. I don't know whether it was over email or on the phone about how that we were contributing this material to the effort and how they were going to approach it.
You don't recall that Director Brennan said it should not be included as part of the ICA because it has not been verified?
I don't know whether it was Brennan. I remember being told that the group's view was it was significant enough and consistent enough with other intelligence that it ought to be included, but it wasn't sufficiently corroborated to be in the body of the intelligence community assessment. So they put a brief summary of it in an annex.
Mr. Comey, you're aware that when we try to reauthorize laws like the Foreign Intelligence Surveillance Act, which is essential to our ability to protect the national security of the United States, there are members of this body and people on the outside who question whether Congress should have that authority, the intelligence community should have that authority, because they think those tools will be abused. Are you familiar generally with that?
Yes, I participated in those reauthorization debates throughout a lot of my career.
I know you have. Does it concern you at all, as a former leader in the intelligence community, as director of the FBI, that the questions that have come up as a result of the Horowitz Inspector General report, the information we know now about the flaws in the Crossfire Hurricane investigation, including the use of the Steele dossier, the inclusion of less than complete and accurate information by an FBI attorney as part of the predicate for that, does it concern you that the questions that have been raised here will make it harder, perhaps even impossible, for Congress to come together and reauthorize important tools like the Foreign Intelligence Surveillance Act?
Yes, and it concerns me even more that the Inspector General found mistakes in every FISA application that he reviewed, well beyond the particular case we've been talking about. So yes, it concerns me.
Senator Durbin.
Thank you, Mr. Chairman. Thank you, Mr. Comey. Mr. Comey, is personal debt an important consideration when an individual is seeking a security clearance?
Yes.
Why?
Because a person's financial situation could make them vulnerable to coercion by an adversary and allow an adversary to do what we try to do to foreign government officials we find are indebted, and that is recruit them to our side. So it's a serious issue.
Go ahead. I'm sorry.
So it's a serious issue in any background review.
So someone with substantial personal debt may be vulnerable to influence by a foreign adversary.
Yes. A government official. Yep.
Director Comey, it's been publicly reported that President Trump has a debt of over $421 million, personal debt, most of which has to be repaid in the next few years. My source, New York Times, September 27th. So as a general matter, are there serious risks when someone with hundreds of millions of dollars in debt, personal debt, has access, as the president does, to all of the country's classified and sensitive information?
It's a serious concern when anyone seeking or with a clearance has that kind of financial vulnerability. I don't know the circumstances, particulars of the president's case, but in general, yes.
If the president disclosed his income tax returns, we might be able to know a little more. Let me just say this. This is an important committee with a great history. I've said that before, and I mean it. And I can certainly point to many times in history where the Senate Judiciary Committee was the leading committee, investigative committee, when it came to the United States Senate. I think it is entirely appropriate that we are meeting today to discuss Russian influence on American elections. I can't think of anything more insidious than Vladimir Putin trying to affect the outcome of the American election and overruling the verdict of democracy by the American people. It is a great issue. It is an important issue. There's one problem. Today we're focusing on the wrong election. Today we're focusing on the election of 2016 instead of the election of 2020, the one that is merely 5 weeks away. FBI Director Wray testified earlier this month that Russia is, quote, very active in the 2020 election. Director Wray said Russia is exerting, quote, malign foreign influence in an effort to hurt the Biden campaign. Direct quote. That would seem to be something that the Senate Judiciary Committee might be interested in. Not only that there's a possibility of interference with the American people voting for President of the United States, but that interference comes from a foreign source, Russia, and they really have their favorite in the race, and their favorite appears to be the incumbent president. And yet we are not taking a look at that today. We are going back on a trip down memory lane to 4 years ago to decide whether or not certain documents were handled properly, and I will concede the fact some were not. But let's be honest. If we were doing our job, we'd be talking about the 2020 election, whether American law is adequate to discourage the Russian intervention, and what steps we are taking as a nation to protect the integrity of the election process. We are not doing that because the agenda here is all about a dossier written 5 or 6 years ago. Well, that may be of interest to some, but not to most of the American people. And I think it really comes down to some fundamental questions. Why, if we are embarking on this escapade into 2016 and what preceded the Russian interference in that election of 2016, why did we decide as a committee on a partisan basis to reject my effort to include subpoenas of Trump campaign manager Paul Manafort and so a Russian agent Konstantin Kilimnik? If we wanted to know everything about 2016, why wouldn't we subpoena them? But yet, on a partisan roll call, this committee decided not to. Not interested. Don't want to get into probing it. We have lots of questions today of Director Comey as to whether he read every document, when he read it, if he did, what impact it had on him. But when it came to these two key witnesses whose names appear over and over and over again in the Russian interference of the 2016 election, this committee, on a partisan roll call, rejected my effort to extend subpoenas to these two individuals. Is there some information we don't want to know? from those two people? I think there's a lot of questions that have gone unanswered. I also want to make it clear this notion about the Steele dossier. Let me ask you this, Director Comey. Was the Steele dossier the reason that the FBI began looking into Russian interference in the 2016 election?
No.
Are you aware, Director Comey, that none, not one, of the 37 indictments and 199 criminal counts resulting from the Mueller investigation relied on the Steele dossier?
I have read that.
I think that makes the case that all of this attention on the Steele dossier, as fascinating as that document may be, did not have direct relevance on the conclusion that the Russians were interfering in the 2016 election or the indictments that followed from the Mueller investigation.
If I may, thank you. I'm sorry.
My time up?
No.
Oh, thank you. Let me ask, if I might, on a statement made by the Attorney General. Let's see if I can find this to be sure I got this accurately. On May 18th, Attorney General Barr gave a quote at the Department of Justice press conference. He said, "What happened to the president in the 2016 election and throughout the first 2 years of his administration was abhorrent. It was a grave injustice. It was unprecedented in American history." The Attorney General went on to say, "The law enforcement and intelligence apparatus of this country were involved in advancing a, quote, false and utterly baseless Russian collusion narrative against the president," end of quote. Then he went on to say, "The proper investigative and prosecutive standards of the Department of Justice were abused, in my view, in order to reach a particular result." Director Comey, would you comment on that statement made by Attorney General Barr about the men and women in the Justice Department?
He says that a lot. I have no idea what on earth he's talking about. This was an investigation that was appropriately predicated and opened, that had to be opened, and that was in the main conducted in the right way, picked up by the special counsel, led to the indictment of dozens of people, and a finding by your colleagues in the Senate that the head of Trump's campaign was a grave counterintelligence threat to the United States of America because he was funneling information to a known Russian intelligence officer. The notion that the Attorney General believes that was an illegitimate endeavor to investigate that mystifies me.
Thank you, Director Comey.
Thank you. If I could just respond a bit to what Senator Durbin said about the committee. I'm not here to suggest that the Russians did not interfere in the 2016 election. They did. Would they try to interfere in 2020? They would. They are. Is China trying to interfere? Yes. So we've have briefings about this. I'm very concerned about it. But what brought us here today is that I supported legislation with my colleagues on this side of the aisle and your side of the aisle to make sure Mr. Mueller could do his job without political interference. Well, after 2.5 years and $25 million and 60 FBI agents, that job is done. Not one person has been charged with colluding with the Russians in the Trump world, not one. Now, when we look into the work product, and I've asked Mr. Mueller to come and tell us about the Mueller investigation, he has chosen not to come. If you want Mr. Weissman to come, I would invite him. The committee is trying to save the FISA system. The FISA warrant applications against Carter Page should make every American concerned about how off the rails this system got. That the document necessary to get the warrant against an American citizen, the key document, was prepared by somebody on the Democratic payroll who hired a Russian suspected spy, and all the information in the dossier fell apart over time, and the court was never informed of the exculpatory evidence that was coming in. And what astounds me the most is that the director of the FBI in charge of this investigation involving a sitting president is completely clueless about any of the information obtained by his agency to throw suspicion over the document that the subsource was a suspected Russian agent. That when he was interviewed, he said it was all bar talk, hearsay, should be taken with a grain of salt. That the CIA told the FBI in December, this is internet rumor. None of that made it to the court. None of that. and he didn't know any of it. How is it possible that an investigation at this level, that none of this information that's damning to the case against Mr. Page never makes it to the top? And you want us to reauthorize this program with a system like that? Everybody's responsible, but nobody's responsible. Somebody needs to be responsible for misleading the court, excluding information to the court that was exculpatory, that would have mattered. How would you like your client to be treated like this? So my point is, I am trying my best to understand how the warrant application failed so many times, how the court was abused over months, and nobody seems to be as concerned about it as I am. Well, count me in about being concerned about Russian interference in 2016 and 2020. But if this committee does nothing else, it is up to us to find out how it got off the rails, how an FBI lawyer could doctor a document that was exculpatory to the subject of the investigation, be charged with a crime. How could that happen? Is there no checks and balances in the FISA process? Is there no duty to be candid with the court when you find something exculpatory? How do you present a document full of information? There is no consulate, Russian consulate in Miami. You had information, the whole sexual escapade thing was Russian disinformation, and it never made it to the court. How are we supposed to trust this system without fundamentally changing it and holding people accountable? One last question to you, Director Comey. I'll turn it over to Senator Lee. Knowing then what you know now about all the things that we've come to find, would you have still signed the warrant application against Carter Page in October, January, and April?
No, I would want a much more complete understanding of what we were.
Thank you very much. Senator Lee.
You know, Mr. Chairman, it's a technical thing, but when you speak over the witness, your voice blocks out what the witness said, so we don't know what the witness said.
Okay, I'm
So
sorry.
I think it would be helpful if you allowed the witness to
Yeah, I'm
complete his
sorry.
answer.
Yeah.
In a regular hearing with
Yeah.
the witness here, we can
Okay.
hear what the witness is saying, and
Could
the
you repeat your answer?
stenographer
Fair
can
enough.
put it down.
Fair enough.
But
Yeah.
you block him out as soon
I'm
as you will
sorry.
talk over him.
I'm sorry.
So if
Could
you
you
could let him
repeat?
finish.
I'm sorry. Repeat your answer. I'm sorry.
My answer was no, not without a much fuller discussion of how they were thinking about their disclosure obligations to the court.
Thank you very much. Thank you, Senator Whitehouse.
Thank you, Mr. Chairman. This is an issue that's concerned me for a long time. The Foreign Intelligence Surveillance Act has some problems. Those problems have been on live display today. They've been on live display over the last few years. I've been working over the last decade to try to reform them. I've forced a number of bipartisan proposals to do precisely that. Most recently with the Lee-Leahy Amendment, one that passed the Senate, that would have passed the House, but the vote for it was canceled. I hope still to get that passed. It is a dangerous thing to provide the enormous investigative power of the United States government. And you gave us a really encouraging speech in which you gave your heartfelt sentiments about what it means to be an assistant United States attorney. I remember specifically your admonition that it's important in a job like that where you have to see things that, as you put it, people shouldn't have to see. It's important to love someone. It's important to dot your I's and cross your T's. And I remember something inspiring you said. You said, if somebody woke me up, at the time you were serving either as the Deputy Attorney General or the head of the Criminal Division of the Department of Justice, I'm not sure which. You said, in the middle of the night, if someone woke me up and they would say, who are you? I would identify myself as an assistant United States attorney because deep down, that's who I am. That inspired in me for many years a level of commitment when representing the United States government to make sure that I was thorough. You inspired me. For that reason, when you were nominated to the position of FBI director, even though I had some grave concerns with the FBI and how it was administering FISA at the time, I trusted you. I believed that you would act in good faith when I asked you in my office and later in committee hearings, first in your confirmation hearing and then in all of our subsequent oversight hearings, what you would do to help make sure that the FISA process was respected and not manipulated. You gave me your word. And having established that brief relationship with you all those years earlier, I trusted you. I have to say today, I'm very disappointed to see that those promises now to me seem very insincere. Now, Mr. Comey, with all due respect, you don't seem to know anything about an investigation that you ran. So how can you now, as a private citizen and former FBI director, show up and then speculate freely regarding any alleged ties between President Putin and President Trump? I heard you say just a moment ago, now I hope I misunderstood you. Please correct me if I did. I think I heard you say that you still speculate they might have something on President Trump because of how President Trump refers or doesn't refer to President Putin in public. This, of course, takes into account nothing about the fact that sources you've relied on in the past have turned out not to be accurate. You didn't identify the inaccuracies subsequently to the FISA court. It acknowledges nothing about the fact that there are perfectly reasonable explanations as to why one leader would refer to a foreign leader in a certain tone, or the fact that this is the same tone that he uses in referring to other world leaders, particularly those world leaders in parts of the country where we've had some issues. So honestly, how can you as a private citizen now come to us and in your capacity as former FBI director and speculate so freely regarding these alleged ties when you don't seem to know anything about this investigation that you ran?
I'm sorry, Senator. I can as a private citizen because I have eyes and ears. And I said in response to the question, that's how it strikes me watching the president in Helsinki take Putin's side against his own intelligence community and lots of stuff like that. And so I separate the two. I agree with you. There are serious reasons to worry about the FISA process when the Inspector General found errors in every FISA application. And that's a really important thing to dig into. And I respect this committee looking at it. So that's how I think about those two things.
Okay. I'm glad to hear that we share that in common. That's something we can build on. That's fantastic. Why do you not think that you had a duty to provide all the information to the Foreign Intelligence Surveillance Court? I mean, you signed the renewal application, did you not?
I signed the certification, which is very narrow.
Got it. What does that mean? What the heck does the certification mean? If you weren't required to know, and in fact did not know what was in there, and if you didn't have any duty to provide all the information to the court, what does that certification mean?
Well, I was trying to say, Senator, when you started speaking again, the certification is narrow that the FBI director has to sign, but that doesn't change the fact that the FBI has a duty of candor, of heightened candor to the FISA court, and it wasn't met according to the Inspector General here. That's a separate question from whether the FBI director should have been briefed on the individual portions of the Carter Page investigation. I know people care about that. Much more important, why were there material omissions, not just in this application, but in all the applications that the Inspector General looked at? So I think that's a really important question.
Okay. We have to remember that the only reason, the people who did this, I'm confident, number one, that the circumstantial evidence suggests that there likely was a political motive. In fact, one of the reasons that we know that is that in various documents that we've obtained, we can see political motives coming into consideration. But in many instances, those individuals didn't believe they had any chance of getting caught. They believed Hillary Clinton was going to win. Had she won, in all probability, none of this would have come to light. How should this strike the American people, the average American citizen, knowing that any American citizen could get caught into the same type of trap, could become the subject of an investigation rooted in the Foreign Intelligence Surveillance Act? It would never come to light. If in this circumstance, where there was always a possibility that it would come to light, and it did come to light because the individual who was connected to the investigation became elected president of the United States, despite the best efforts or perhaps the expectations of those conducting in the investigation. How should they have any confidence in the FISA process when certifications were provided, but the full information wasn't? When the duty of candor to the court wasn't met? When no one seems to take accountability for anything, and this entire process is handled in secret with a malleable standard, leaving it almost without accountability? Should the American people have any confidence in the Foreign Intelligence Surveillance Court or in those government lawyers appearing before it?
I'm not going to address your long preamble, which I have a significant disagreement with. The American people should always want to know how the government's power is being used, especially when it's being used in secret. How is it checked? How is it overseen? How is it balanced? And we know, because you've been around a long time too, that periodically we discover problems in any ex parte process. The American people should have confidence in the oversight of the Inspector General especially, and of this committee and your counterparts in the House to demand those answers. I think that's totally appropriate.
Okay. Mr. Chairman, I see my time's expired. You don't install a wasp nest in your child's bedroom and then express surprise when the child gets bitten by wasps.
Stung.
You don't adopt an ex parte process and then express surprise and outrage when it goes completely unsupervised and off the rails. This is an issue that's neither Republican nor Democrat. It's neither liberal nor conservative. This is a constitutional issue. This is a moral issue, and we've got big problems. We need to pass the Lee-Leahy Amendment, and we need to reform or eliminate the Foreign Intelligence Surveillance Act. Thank you.
Senator Whitehouse.
Thank you. Mr. Chairman, I am particularly sensitive to the problem of selective declassification because I had to go through being on the receiving end of a lot of selective declassification during the Intelligence Committee's investigation of the torture program. And I will tell you, it is extremely frustrating to have information declassified, in that case out of the White House, that you know can be exploded, completely blown up by other information, but that other information hasn't been declassified. So you can't answer the false implication from selectively declassified information. So from that background, I am really concerned that we are treating this Ratcliffe letter as something at all serious or credible. And Mr. Chairman, I hope very much that nobody from this committee had any hand in generating this letter. We are recipients only, I hope, because if we had any hand in this, that's a real problem. I will point out that with respect to allegation, bullet 1, talking about tying Trump to Putin and the Russians hacking of the Democratic National Committee, that's actually an established fact. With respect to the point about a proposal from a foreign policy advisor claiming interference by Russian security services, that is an established fact. And the U.S. presidential candidate Donald Trump and Russian hackers hampering U.S. elections is also an established fact. So what else you have around here is what looks like just something that got spun up by a political appointee and is now being offered through this committee as having any credibility. And I think that this rings just innumerable bells about the dangers of selective declassification. So there's topic 1. I've got a problem with selective declassification in our proceedings here. Second, I've got a big problem with access to documents. You and I have talked about this. You know that I've made public statements about how the FBI appears to have had a policy, for damn sure a pattern, of refusing to answer questions, refusing to answer QFRs, and many cases to Republican senators, but for sure to Democrat senators. You took that claim seriously enough that you organized a meeting for me with the Deputy Attorney General to explain this policy or this pattern of not answering questions. That was on June 15th, as I recall. And here we are nearly into October. And do you know how many answers I've gotten since that meeting? 0, none, not a single one. So when it comes to our questions, it looks like it's a total stonewall. In this case, on this matter, the DOJ has given the chairman unprecedented access to information, including deliberative documents, stuff that they wouldn't give us even if they were answering our questions, and classified information, which usually is a mare's nest to get through. 18 separate productions of highly sensitive documents totaling 1,550 pages. So this particular question seems to be getting high-speed special treatment out of the DOJ, when in other areas we get a complete wall of silence and shutdown. And the last is, I'm told that there are even private briefings to Republicans only on this matter in which Democrats were not invited to participate. Again, if that is true, a combination of selective declassification, dishonorable and unfair access to documents, and partisan private briefings does not get us off to a good start, going back to my letter to you of June 4th about the hazards of this investigation. So I just needed to say that. I agree with you, Mr. Chairman, that it is worth looking into the question of what is wrong with the FISA process that allowed these repeated errors to happen across a whole array of cases. But it's also interesting to read the Gleason brief, where a retired federal judge, on behalf of a federal judge, accused the Department of Justice under Attorney General Barr of running political errands for the president in order to protect a political supporter and friend of his, Mr. Flynn. And we have exactly zero attention being paid to that. That is a fairly serious matter of interest, I think equivalent to the matter of interest in FISA, but nothing. The current FBI director is talking about present Russian interference in this election right now as we speak to try to get President Trump reelected. Where's the hearing on that? Where are the documents on that? Where's the declassified material on that? None of it. And, you know, I'll go back to what I considered, because I don't have any information because the FBI has given me none, what appears to have been a bogus tip line in the Kavanaugh investigation. Maybe it was, maybe it wasn't, but a question about whether that was a bogus tip line, I think is something that is worth answering. And yes, it is important that the FISA process was abused, but if an FBI investigation was abused in the Kavanaugh hearings, that's also an important matter. So I don't want to deprecate the importance of what we're doing here, but I do think it stands in a very sharp contrast to other issues with the FBI that are continually swept under the rug and continually stonewalled. The question that I have is something I've raised before, and I'll ask Director Comey, because he's done a lot of investigations. You and I have done investigations as well, Chairman. You've been a prosecutor. If you have an investigation, and if you determine in your oversight as a supervisor that there is a flaw or an omission or a false statement in a warrant application, obviously you should not file that warrant application with the court. The problem is that the committee's questions on the Republican side have always ended there. You would not sign the warrant if you knew that was the case. The problem with that is that you then go on to the next step, and that is just because there was a flaw in a proposed warrant doesn't mean you end the investigation. You're nodding your head. We both agree. At the end of the day, what you then do is you go back and you look at whether the investigation was otherwise predicated with all the falsity or whatever removed and everything accurate that needs to be in there done. And if then the investigation was otherwise predicated, and if then there was otherwise probable cause to continue, Director Comey, do you not then proceed with the investigation with a cleaned up warrant rather than let somebody get off scot-free because of an error that never reached the court?
You'd certainly want to go through, I think that's called the Franks process, to understand whether you still have sufficient basis to establish probable cause with the mistakes and omissions corrected.
And that is standard FBI practice, correct?
Standard prosecutorial investigative practice across
the board. Thank you.
Hey, respond and turn it over to Senator Cruz. Number one, Senator White House has reason to be concerned about some testimony given in the House by a Department of Justice official about environmental policy. And we will keep plugging away with me and you and Senator Lee because this is a legitimate inquiry.
Just to be clear, Chairman, yes, I'm very concerned about the antitrust investigation and who was behind it and
Yes.
why it seemed to violate so many rules and
Yes.
norms.
Yes.
And when we get around to Senator Lee and Senator Klobuchar's antitrust investigation, which was supposed to be today but has been, I gather, indefinitely postponed, I would hope that we have those documents. But the list that I gave to the Deputy Attorney General of all of the QFRs that I've not had answers to and of all of the questions and letters I've not had answers to goes well beyond that one issue of the Del Rahim investigation, of fake investigation, and it would seem, but we'll see, of the auto companies.
Yeah. And just to make it clear to the public at large, because the Carter Page warrant application was incredibly flawed, doesn't mean you can't look at other things. The question for me has always been, okay, let's look at all things Trump. In the dossier, they accused Carter Page as having a relationship with Manafort, and that's where he's passing all this information. Carter Page never talked to Manafort. That's things that the court should know, allegations being made. We now know that the dossier was a result, at least in part, of Russian disinformation, that the FBI took Russian disinformation from a political party, paid for by a political party, and got a warrant against an American citizen, and that's pretty stunning. And we got to do something. Somebody needs to go to jail or get fired over that. Now, the question has always been, did the FBI have the same zeal looking at Trump? Let's put it this way. Everything Trump got looked at. People's lives were turned upside down. $25 million was spent, and nobody's ever been charged with colluding with the Russians on the Trump side. Was there any suggestion maybe the other side was involved in trying to create a Russian-Trump problem for political purposes? We know that Christopher Steele was on the payroll of the Democratic Party. We know that he was working for Fusion GPS. We know that his primary subsource was Igor, the Russian spy. If they were willing to do that, would they be willing to do more? We know in July there's an intercept out there from Russian intelligence analysts that the Clinton campaign is concocting a strategy to tie Trump to Russia. All I'm suggesting is, did they look at that? And Director Comey has told me he doesn't remember getting an inquiry from the intelligence community about a September concern about the Clinton campaign trying to change the subject from the server to Trump Russia. He doesn't remember that. So what kind of system do we have? We look at all things Trump all the time, and when we get exculpatory evidence, we keep looking. When we told it's not reliable, we keep using it. And when there's suggestions that the other side may be up to no good, we just ignore it. That's why the Radcliffe information is important to me. I haven't been privately briefed by anybody, but I'm beginning to understand there was a two-tiered system here. When it came to Trump, there were no rules. Plow ahead, ignore everything, lie if you need to, alter documents. When it came to Clinton, seems to be a completely different standard, knowing that the campaign had on its payroll a foreign agent who hired a Russian spy to get dirt on Trump. That is the concern I have, and we can't live in a world where you turn the world upside down against one campaign and give the other campaign pretty much a complete pass regarding Russia.
Mr. Chairman, since you've responded to me, may I have a moment back to you?